All right, welcome back to the Judiciary Committee, and we're now going to turn to H745, an act relating to the Vermont Parentage Act, and we have a tag team who is going to walk us through what the parentage law is and what this bill does. And if you all could introduce yourselves and for the record and proceed.
So for the record, Michelle Childs, Office of Legislative Counsel, and I just want to introduce so Jessica Seaman, General Counsel for Office of Child Support, and Polly Crozier is on Zoom for GLAD. And I have been working with them for months on this draft to revisit the parentage laws after it was enacted in 2018. And so they are the real experts in the field on this, and I think will be very helpful for getting your head around what is honestly a pretty complicated area of law. So that's going to tell them a little bit, because I don't think most of y'all have ever dealt with child support since you've been on this committee. So
thank you, committee, for having us here today. My name is Jessica Seaman. I am the lead attorney for the Vermont Office of Child Support, OCS for short. We are a division of the Department for Children and Families, and we are the agency that we are sort of duly administered by both the state of Vermont and also the federal government. So the federal government has implemented funding to each state to have a child support agency under Title 4D of the Social Security Act. And so OCS is Vermont's Title 4D agency. We provide free child support services to any person who applies for our services. We also receive referrals for cases from economic services for families who receive Reach Up Family Assistance and have assigned their rights to child support to us. The majority of our cases are actually non-public assistance cases, and a huge part of what we do, aside from collecting and dispersing child support payments, is we help families go to court to establish parentage and other parental obligations. We are the biggest user of the family division of the Superior Court. We kind of function like a big law firm. We have 6 regional offices, 5 offices in the different corners of the states, where we have caseworkers who are the frontline workers working cases, paralegals who help us in court, and then we have attorneys in each of our regional offices and a regional manager. So this law is a huge part of our work. We analyze all of our new cases using the Parentage Act, and as Michelle said, this is a huge law. When it passed in 2018, it really modernized the way that parentage is established for Vermont children. It's been working great, but we've got to work a few things out. And I think that's all I have to say about me.
And my name is Polly Crozier. I'm the Director of Family Advocacy at GLAD. And I'm also a family lawyer by training. So I have had my own practice for over a decade, and before moving to GLAD and at GLAD, I actually do considerable amount of work on parentage law reform with the goal of protecting all children, no matter the circumstances of their birth. And I also have the pleasure of serving on the Uniform Parentage Act National Enactment Committee. So I work with legislators and academics and legal experts across the country working on parentage acts in various states to make sure that they remain best practice and consistent with the best interest of the children and really aligned with federal law as well. So it's a pleasure to be here today. And from what I have heard, I think, I was part of this process in 2018, which was such a thorough and careful process. And I think, from my perspective today, there's a few tweaks that will be very helpful. But, just grateful for the work of this committee in the past and the present to get it right for Vermont children and families.
Thanks, Polly. So I'll just give you a little history on how we got here. So I think my first dabbling into the parentage laws was in 2000, when this committee was working on a bill to create civil unions. And my task there was essentially creating a parallel separate system to marriage and marriage rights, benefits, and responsibilities. And as I was doing that, I was looking at the parentage laws, and there was something in there talking about a child born to people in a marriage is presumed to be and it said natural child of those two people. And I said, well, does natural mean biological? And what does that mean? And how does that translate if I mirror that in a civil union, right? And I said, well, we got to figure this out. And at the time, there was so much going on. They were like, we can't quite tackle the parentage laws also right now. But we'll get back to that, right? And so then 18 years later, Justice Dooley was preparing to retire. And he asked to come before this committee and said, I have one ask of you before I go. Will you please fix the parentage laws? They are so antiquated that that the judiciary struggles on a daily basis to apply them to the way that modern families look, right? And it was true. I mean, they're really the statutes were very old, and the case law coming out, they were just guessing. There was a case called the Miller-Jenkins case that was brought years after civil unions was adopted, and it was right on this particular issue that I had raised back in 2000, right? And the court got it right. They said that the two women who were in a civil union who had a child that was born during the civil union, that both of the women who were parties to the civil union were the legal parents of that child. But it had to go to court, and the court to kind of grapple with it and things like that. And so you don't want that. You want to be clear about this stuff. And so Justice Dooley said, please adopt the Uniform Parentage Act. And then that set forth this whole process. And I think, as I mentioned earlier, I worked a lot with Polly. I also worked with Susan, and who was at Langrock and Sperry, and Office of Child Support, and everyone was tremendously helpful having those practitioners. And it's not a partisan issue or anything like that. It's really just like a process issue about how you go about establishing a legal parent. We're not talking about parental rights and responsibilities like we talk about in Title 15, where we're talking about the, care and custody and legal rights there. We're just talking about the establishment of who is a parent under the law. So I'm going to share my screen to just show you a little bit of what we have here. There we go. So we actually created, I look back at it now and it's so skinny, maybe I shouldn't have, but I created a whole new title for parentage because it seemed like it was going to be too big for a chapter. I'm just showing you this. So it is, so you have Title 15 is your domestic relations title. 15A is adoption. 15B is the Uniform Interstate Family Support Act. And then now you have parentage proceedings as Title 15C. So you have a number of chapters. Again, this is modeled after the Uniform Parentage Act, which I think was originally done in like 1973, but then had a number of updates. I think the most recent update, which is what we were looking at, was the 2017 update. And that one was really kind of very focused on trying to make sure that that gender was not kind of embedded in this, and so that it would apply equally for same-sex couples. And then there were a few other things. I think we're recognizing in the 2017 language what they call de facto parents. And those are parents who are not necessarily biological or haven't signed a voluntary acknowledgement of parentage, but have basically, you hear that term in loco parentis, like acting as a parent, putting themselves out there and caring for a child. And so I think that was also new in the 2017 language. So I just wanted to kind of show you the chapters here. So you can have the general provisions, how you establish parentage. And then these are the kind of the different ways that that you can get acknowledged as a legal parent. So Chapter 3 addresses voluntary acknowledgement of parentage. So anybody who maybe has had a child, and I don't know how long it's been, but I know that they were doing it, when I had my kid 16 years ago, whatever, in the hospital, they actually give you a form from the Department of Health where you sign a voluntary acknowledgement of parentage. That is considered a judgment. That is considered legal. You are acknowledging that you are the legal parent of this child. So that is one way. There's also Chapter 4 deals with presumed parentage. So there's different ways on presumption of parentage. Primary way is what I just talked about around the issue of a child born during a marriage. And there's nuances and other avenues for this, but I don't want to get in too deep too fast. De facto parentage, I just talked about. So someone basically holding themselves out and behaving as a parent towards a child. There's genetic parentage, which is just what it means. So you might have a mom who either has not identified who the other parent is or something. So there may be DNA testing to determine who the other genetic parent is. Chapter 7 deals with assisted reproduction. And Chapter 8 deals with gestational carriers. So those are kind of the buckets that we have around that. I wanted to draw your attention to just another basic, which is, I think I have to. That I think will help. So I'm just going to show you again, just trying to ground you in some basics here, which is presumption of parentage. So this, I just thought I'd go through real quick to, kind of, so we can start to get our heads around this, because I think one of the reasons why this area of law is complicated is there's so many ways to become a parent, to be a parent, how families look, right? So here there is a presumption of parentage, and presumptions are rebuttable. So there's ways to challenge this, and we're going to talk about that in a later section of the bill. But just see that except as otherwise provided, persons presumed to be the parent if 1, they gave birth to the child, or they're married and the child is born during the marriage. 2, the person and the person who gave birth to the child were married to each other, and the child is born not later than 300 days after the marriage is terminated by death, annulment, declaration of invalidity, divorce, or dissolution. 3 is that the person and the person who gave birth to the child married each other after the birth of the child, and the person at any time asserted parentage of the child, and the person agreed to be named as a parent of the child on the birth certificate. And 4 is the person resided in the same household with the child for the first 2 years of the life of the child, including periods of temporary absence, and the person and another parent of the child openly held the child out as the person's child. So those are kind of some basics of, there's just an automatic presumption in those particular cases that those folks are the legal parent, unless that's challenged and they fit within one of the exceptions. So now I'm gonna, do you guys have anything to add just on some of the basics? You don't have to.
I think I would say one thing, Polly, you can correct me if I'm wrong, but when Vermont passed the Parentage Act in 2018, as Michelle mentioned, it was based on the Uniform Parentage Act and actually quite a bit based on Maine's parentage law. But I believe that we were looking at the Uniform Parentage Act from 2002, which was what Maine's Parentage Act was based on, because Maine's law passed before the 2017 UPA was officially published. Polly, am I getting that correct?
Well, I'd amend that a little bit. I agree. What I think, and I remember, support Susan, Murray, who was, there was a study committee from which the bill emerged, right? And, my recollection was the study committee took both the main Parentage Act, which my colleague Mary Bonato was involved in helping to draft, and the Uniform Parentage Act of 2017. In fact, the Uniform Parentage Act of 2017, those updates from the 2002 version were quite informed by Maine's Parentage Act, but added on to them. And so what Vermont did was take Maine and take Uniform Parentage Act and adapted for Vermont, which is one of the reasons why you will see that the Vermont Parentage Act update has an updated, really up-to-date voluntary acknowledgement of parentage provisions that Maine did not have until 2 years ago because they had done an earlier version. So Vermont looked at Maine and the 2017 version.
Okay, so I'm going to start to walk through section by section. So starting on page 1, section 1, we're in the definition section that is applying throughout the title. And the change there, and I just put, I put reproduced a lot of the language that isn't being amended there just so you could have those terms for reference throughout the bill. But really the only change is on the definition of gamete. So that's subdivision 10 on page 3. Right now it says that gamete means a sperm or egg or any part of a sperm or egg. And my understanding, and I don't recall why we had it that way the first time. I'm sure probably it was in one of the other versions, but that have found that is a layer of detail and complication that we simply don't need for purposes of the title.
Yes, and statutes in other states moving forward have used a simpler definition of just sperm or egg.
That presumably is the easy change.
Yes. So next change is so section 2. Now we're looking at a parentage proceeding. And there is a provision here. So subsection B makes a change, but we don't need that change, we decided. I think we're just gonna, so I don't think we need to address it. So line 10, it was changing parentage to alleged genetic parent. Just ignore that. We're gonna suggest that that's just gone and goes back to the original language. The next change, and we're gonna ask for a change on this too, is so originally, so you'll see in the law, it talks about a person who's a party to a parentage action shall disclose the person's social security number to the court. And it's placed in the court records. And originally we had talked about this, struck that language. But then in talking with Office of Child Support, after we had gotten the language done, that we discovered that they really need that provision in there. The concern was about social security numbers being public. I think, and I keep meaning to check on this, but I will double check, but I'm pretty confident that those numbers are not public. So there may be a public record or something in a court record, but those, that type of thing would be redacted. So it wouldn't be open to the public. And I will double check on that. So what we'll do for that when you do markup is we'll put something back in there that meets the needs of OCS for purposes of their filings, but we'll probably reference wherever in law, whether it's like 317 in Title I or in the court records rules around just clarifying that those numbers are not to be part of, that they're to be confidential.
Yeah.
So what happens now when someone doesn't have a social security number?
If they legally do not have a social security number, they don't have a social security number, they're not required to provide that to the court. But Michelle is correct. When any court document that has a social security number on it is considered confidential and pursuant to the Vermont rules for public access to court records. Those records are, the social security numbers are redacted and they're not made part of the public record.
I understand the part about confidentiality. I'm asking what happens for people who want to be parents and recognize as parents in the system who don't have a social security number. What happens now and what are you proposing happens in the future?
I don't think we encounter that issue very often in our work. Most people do have social security numbers, but it is true that some families do not, either the children or the parents do not have social security numbers because they're not citizens. I don't think I think that this particular section of the law would not apply to them if they don't have a social security number. But if they did, they are technically required to disclose it to the court.
So it says a person who is a party to a parentage action shall disclose. It doesn't feel open to me, to people who don't have a social security number to go through this process. If we're gonna not remove this section, which I'm excited we're removing it, if we're not gonna remove this section, can we amend it to make sure it's people who don't have a social security number don't feel that they cannot become a parent through
I think
processes?
I think we could consider that language. The reason that we are advocating that it remain in place is because it's required by federal regulation. So, we wouldn't, OCS, we get most of our funding from the federal government, and we wouldn't want to change a law that might jeopardize that federal funding. But I don't know if other states have laws where they've considered that issue. But if someone doesn't have a social security number, I don't think this is prohibiting them from filing something in the family division. But I see your concern about that. I think we have to
I
look
think
into
we'll want to
that.
make sure that there is a clear way for people to do that. Presume, I mean, no question that the vast majority of Vermonters, the people living in Vermont, have a social security number, but that isn't a reason not to make sure that
Sure.
everyone has a way to make sure they can establish parentage. So, yeah, just want to follow up on that.
So if there can be just an exception when we rework that language, that if a person doesn't have a social security number, something to address it.
Right, but we'll definitely want to get clarity on whether or not, because certainly over the years, as I've worked on the child support stuff, oftentimes it has been, the impetus has been a change in federal law that is kind of like states, you must do this or you're going to jeopardize your funding. And so, and it can be quite a bit of money. So, so I'm sure Jessica will check that out and get back with us.
Thanks.
Yeah, and just to chime in, that provision is not in the Uniform Parentage Act of 2017. So it seems like there's probably a way to work it out for the needs of the department and also the needs of Vermonters.
Right. Cool.
Okay, now I'm going to move on to section 3. Now we're looking at a section having to do with adjudicating competing claims of parentage. So if you have competing claims of parentage or challenges to a child's parentage by 2 or more persons, the court is to use the best interest standard. That's a standard that we use in a number of places with regard to kids. So if you think about parental rights and responsibilities around child custody and care, there's a best interest standard in Title 15 for determining those types of things and a list of factors. So best interest is a term of art that is used with some frequency. And then you'll see, so there's a listing there of the factors to consider with regard to best interest of the child. And then you have down in subsection B is that a court may determine that a child has more than 2 parents if the court finds that it's in the best interest of the child to do so. A finding of best interest of the child under the subsection does not require a finding of unfitness of any other parent or person seeking an adjudication of parent. Remember, like kind of the goal here is to make sure that child has got parents, as many parents as who want to be parents to that child, right? And so they don't want to say that if based on family dynamics or however that comes about, they don't want to say, no, there can only be 2 if there are 3 people willing to stand up and care for that child. And so you see the new language there, starting on line 3, is a determination of best interest may include consideration of evidence of pre-birth intent to parent the child. And I'm going to kick this one to Polly to talk a little bit about her experience as to what she's been seeing out there in cases in other states as to why this language would be helpful in guiding the court.
Yeah, we thought this was a helpful way to guide the discretion of the court. Obviously, the court maintains the discretion to determine what's in a child's best interest, but just to flag that pre-birth intent to parent might be quite important for some children. I think we're seeing more and more these days that more than two parents are intentionally establishing parentage relationships from birth and planning to have more than two parents from the outset. You know, for instance, one of the quintessential examples might be two lesbian mothers with a man who they intend to actually have a parent-child relationship. In many cases, that person is intended to be a donor. Some cases, that person might be intended to be a parent, for example, and we would want folks to be able to include that we would just want the court to be aware of, look to what the intent was in forming these relationships so we don't leave folks out who might be in the mix. So just trying to flag that issue for the court, because one of the things we want to do is try to reduce litigation and make sure that, you know, the folks who are intended to be the parents of the child, hopefully at the end of the day, end up being legally secured to them.
Okay, next section, section 4, we're on page 8. And this is challenge to presumed parent. So, you know, we talked about the kind of ways that there's an automatic presumption of parentage, but that there's ways to rebut that. And so, you know, the most, you know, obvious one that I think of is, you know, like a child born to a marriage. Let's say a opposite sex couple, woman gives birth, but she has had a relationship with another man, right? And so, and then you could say, well, I'm not the, you know, and if that's challenged, they could say, well, I'm not the parent. So there's a variety of ways to do that. So you see in subsection A, proceeding to challenge the parentage of a person whose parentage is presumed under that 401 where I gave you the list shall be commenced within 2 years after the birth of the child. So you'll see some timelines in here, and this committee spent a lot of time talking about those timelines and things like that, because you just want to think about the policy behind it is you don't want these things to languish, right? You want certainty just for a child. You want, you know, reliability, dependability, stability for the child. And so, there's this 2 years there for commencing a challenge. However, it can be brought outside of that 2-year period in certain circumstances, which is where you have subsection B. And I think what I'll do, so this is a section that that's particularly important and helpful for OCS. And so I might just have Jessica talk to you about the changes here and what they're seeing as to why they need the language tweaks. Is that all right?
Absolutely.
Okay.
So before we go sort of line by line about the proposed changes, this particular section of the Parentage Act used a lot of the language in the main Parentage Act, but it's different than the UPA 2017, the Uniform Parentage Act. And so one of the things we're trying to do with this bill is incorporate some of the provisions from the Uniform Parentage Act, the 2017 version, to help clarify how a challenge can be made and who can bring that challenge. And the reason it's important to our work is because we have encountered situations where a person with OCS services wants to establish parentage and child support for their children. But in one example, one of the children was born within 300 days of her divorce from her ex-spouse. The alleged genetic parent, they actually tried to sign a voluntary acknowledgement of parentage, which Michelle alluded to. It's an administrative way in the hospital where you can acknowledge that you are the parents of the children. They actually signed one of those documents, but didn't realize that it wasn't valid unless the ex-spouse signed an accompanying denial of parentage. And to be quite honest, most people don't know these laws. They probably assumed I'm divorced, no big deal. We can sign this form. And then they actually went on to have several other children together. Now they're in court and we're having a parentage hearing, and the magistrate realizes that the birth parent, the mother, doesn't have standing to challenge the presumption because the child is more than 2 years old. And if you read through the current statute, the way the statute is currently drafted, it does allow a challenge to be brought after that 2-year time frame, but only if by a presumed parent. So it wouldn't be the birth parent, it would be, their spouse or their ex-spouse who is not the genetic parent of the child and who could not have reasonably known about the birth of the child. They have 2 years from discovering that they are not a parent to bring a challenge. And then conversely, the statute allows an alleged genetic parent who did not know of their potential parentage to bring a challenge to someone's presumption of parentage within 2 years of discovering their potential parentage. But you can't fit a birth parent into either of those categories. And so we have a case where we have a family and we can adjudicate parentage for 2 kids, but 1 child. The court couldn't adjudicate parentage because no one had standing to challenge the presumption. And so that has a real effect on families. We've had a couple of other scenarios that sort of similar, mostly involving the presumption of marriage. We have a lot of Vermonters who are married, but they don't get divorced. They split apart. They go on with their separate lives and don't think about the consequences of how they might go about establishing obligations for their children if they haven't divorced and there's another parent in the picture. So what we're trying to do with this amendment is incorporate some of the language from the UPA 2017, which it's kind of complicated and we can walk through it, but I think it does allow for these challenges to be brought by a birth parent or another parent if it's in the best interest of the child. And so the first part of section B explains that you can bring a challenge after that 2-year time limit in any of the following circumstances. And we amended section 1 to explain that the presumed parent is not a genetic parent, never resided with the child, and never held out the child as the presumed parent's child. And so I think what that's trying to accomplish is, it really addresses the scenario that I was just describing. The presumed parent has never had a relationship with the child. They haven't lived with the child, and it doesn't seem reasonable to presume that they are a parent of that child. And that could be brought by either the presumed parent or the birth parent or another potential parent. The second subsection of B, we didn't change, and that's the subsection that allows a potential alleged genetic parent to bring a challenge within 2 years of discovering their potential parentage. And that provision really exists because people do have constitutional rights to assert their parentage, but they can't sit on those rights. They have to do it within a reasonable period of time. So we didn't make any changes to that subsection. And let's see,
Can I ask a question?
Yes.
I guess this is complicated, and I dealt with this for, it seems, weeks, a few years ago, but apparently all of that knowledge is gone by the wayside. So yeah, this is, I guess I'm not following you. It sounded like you're saying that the birth parent can't bring the case. How does this change that they can now bring the challenge?
So I think that's a good question. And I think it changes that because the judicial officers were reading section 402 and I think this is probably a plain textual meaning of the existing law, to say that only a parent whose parentage is presumed can bring a challenge after the 2-year time limit, or an alleged genetic parent. but a birth parent is a birth parent. And they're not, I mean, they're also not an alleged genetic parent because they gave birth to the child. So,
I guess I'm not seeing the language that they were interpreting that way as well.
okay, this is tricky. So the existing law, I'm going to read the way the law.
This is the presumed parent? Or-
Yes, I'm going to read how the current version of section 402 reads.
Okay.
Except as provided in subsection B of this section, a proceeding to challenge the parentage of a person whose parentage is presumed under section 401 of this title shall be commenced within 2 years after the birth of the child. So if you're within that 2-year time frame, you're not time barred to bring a challenge. Then subsection B says, a proceeding to challenge the parentage of a person whose parentage is presumed under section 401 of this title may be commenced 2 years or more after the birth of the child in the following circumstances. 1, a presumed parent who is not the genetic parent of the child and who could not reasonably have known about the birth of the child may commence proceeding under this section within 2 years after learning of the child's birth. So I think when you read that, and we know that court magistrates and judges have read that to say, well, it couldn't be the birth parent because they would obviously know about the birth of the child. So that section really only applies to a person who is presumed to be a parent and not the birth parent.
Okay. Now I see.
I
Yeah.
still don't.
So-
There's the 401 about who has the presumption there and where the birth parent language comes in.
Except as otherwise provided.
So when it's referring back to someone who is a presumed parent under 401.
Oh, right, you went over that.
Just to check my understanding, so the issue here is that the ex-husband was a presumed because it was under this 401A2 language, and then this person, and then they find out at some point later and say, hey, we want to challenge that person's parentage, but they can't because it's not within 2 years.
So in the example that I gave, it wasn't the ex-husband who was challenging the parentage. It was the birth parent and the genetic parent of the child who were the parties to this case. And because birth parent that doesn't meet the criteria under section 402B1 to challenge a presumption, the court said, you don't have standing to challenge this presumed parent's parentage.
Can you back up just for 1 minute? So the ex-husband would have been a presumed parent under number 2 or something like that, number 1 or number 2, is that right?
That's
So they were presumed under that, but they weren't the genetic parent or the birth. And they wanted to challenge that person's assertion of parentage, the ex-husband, right? They wanted to say, you're not the presumed parent.
In our case, the ex-husband had not, well, we were required to give notice to the ex-husband as a potential parent in the action. And he did not intervene in the case, probably because he didn't think he had a reason to. He knew he wasn't the parent and he wasn't. It's not clear in the case that I'm providing, the example I'm providing you, that he even would be able to challenge the presumption, because if he knew about the birth of the child, even though they were divorced, under subsection of the parent law B2 or B1, sorry, he could only bring that challenge if he didn't know about the birth of the child. And then he would have to bring the challenge within 2 years.
Just to confirm, then to Angela and Karen, a presumed parent who is not the genetic parent of a child and who could not reasonably have known about the birth, and the birth parent obviously knew about the birth.
Correct.
That's the key.
That's correct. And I will say presumptions of parentage are really tricky. This is old law. These presumptions are based on presumptions of legitimacy. And as what we've been trying to do is recognize that, not all marriage is not what it marriage is not what it was back in colonial England when, these presumptions appeared in the law. And that families are more complicated now. And we have a lot of parents in our cases who are poor, who are estranged from their spouses, who can't get a divorce because they can't locate their spouse, but they've gone on and continued their lives and had other children. And so if we can't even find that husband, I'll use gendered terms here, or serve that husband, or they don't have a basis to challenge it, we're kind of stuck because a birth parent is a birth parent. They aren't the presumed parent. It would be their spouse or the person who they were married to, who they divorced, but the child was born within 300 days. There's other presumptions we haven't even touched on here, but.
Angela and then Karen.
So I think I'm glad you said what you just said, because I think that's what my question is about. So this change doesn't, I believe you said earlier that no one had standing in the example that you provided. No one had standing to bring this challenge. And this change provides standing for the presumed parent who's not the genetic parent, but does nothing to provide standing to the birth parent.
I think the amendment that we're trying to enact here would give standing to the birth parent. If the birth parent can say that the presumed parent is not a genetic parent, they've never resided with the child, and they have never held themselves out as a parent of that child. So in the example I gave, the birth parent, I think she more or less testified to this. I haven't seen my ex-husband in 7 years. He's in California. He's never met my new children. He's never lived with them. And so this language that we're trying to incorporate into Section 402 would give a birth parent the right to say to a court, it's not in the best interest of the child for the court to presume that my ex-husband is a parent when he's had no relationship with the child. And I think the courts are struggling here because that's a scenario where it doesn't make sense. Why wouldn't the court want to adjudicate parentage for the person who says they are the parent and has a relationship with that child?
Right.
So we're trying, I think, to give the court some guidance about how to deal with these tricky legal issues.
Karen and then Joe.
Yeah, so for me, I feel like the two words that have been deleted that clarify is the may commence. I feel like that probably was part of it because it's kind of identifying one person that may commence the challenge.
That's what my question
And
is.
I feel like that's what we're trying to open up is anybody can commence the challenge in this situation. I feel like that's the clarity we're trying to get. It's when these situations arise, anybody can create the challenge, not just that one person. That's what I'm hearing.
That's my follow-up, but this makes, the way I read it, I thought that the presumed parent who is not the genetic parent had to commence the challenge.
I feel like that's where the distinguishing is. Like we want to be able to say anybody can, in these situations, any of the involved parties can initiate a challenge.
I see what you're saying. I think that the way that I'm reading this is that an action challenging a presumption can be commenced if you meet the criteria in one, which is you can tell the court or show the court that the presumed parent, the person whose parentage you're challenging, is not a genetic parent, never resided with the child, and never held out the child as the presumed parent's child. We could probably.
I
put some
understand
language-
what you guys
Yeah.
are saying here,
Yeah.
and I have a little fix in my head, but I want to talk to folks about it. But if I can clarify it a little bit with where you're going, I'll do it. As long as it doesn't somehow mess up hit some domino and everything else falls, which I just want to make sure.
Use of litigation or something.
Right. So I have a plan, but I want to talk to folks first before I do that.
Joe.
So I have the same concern that Karen has, but a little twist on it, which is that under the current law 402B1, the term may commence, in my mind, limits the standing. So there's only one person who has standing in an action such as this. It is let's see, a presumed parent who is not the genetic parent of a child who could not reasonably have known about the birth may commence. So it's that person who's the presumed parent with those modifiers attached to it is the person who may commence. And so my twist on Karen's concern is that what now, now there's no limits around who has standing on this. Any person may challenge the presumed parent status because there's not the may commence limiting language there. And I guess my first question is, am I totally off base, which is always a possibility? And if not, are you concerned about that? Is there a change there that might be, or am I just off base?
So what we did when we put together this draft was we looked actually at Connecticut's Parentage Act, which was recently, they recently passed their parentage law, and they included, actually, their prior law was very similar to our existing law, but they changed their law and incorporated more of that language from the Uniform Parentage Act. So what we didn't want to, go rogue and do something that was unconventional. So we actually, this section 402 is nearly identical to Connecticut's law. I do understand your concern, and I think that, when you're bringing a parentage action, other sections of the Parentage Act do explain who has standing to bring a parentage action. And so you have to meet that criteria. A child has standing to bring a parentage complaint. A parent who meets any of the criteria of the other chapters of the Parentage Act has standing to bring a complaint. So I don't think that, if you're a grandmother or a foster parent, you don't necessarily have standing unless you're making an argument that you're a de facto parent, which is a whole different chapter of the VPA. So I do think that standing would be limited to the birth parent, to a presumed parent, or to an alleged genetic parent, but they would have to show that the presumed parent never had a relationship with the child, because that's the primary focus of the VPA, is to ensure that parentage is adjudicated in the best interest of children. And a lot of that hinges on whether there's an established relationship between the child and that parent. So this is actually a pretty high bar, because the language says you can challenge a presumption after that 2-year period, but you have to show that that presumed parent never lived with the child, never had a relationship with the child, is not the genetic parent of the child. That being said, if we can come up with some little tweak, as Michelle was suggesting, that might make it clearer, and I'm all about making it clear because, I think the courts are looking for that clarity as well. We can certainly try to do that. I don't know if that helps.
Yeah, it does. Thank you.
The Office of Child Support also has standing, right?
We have standing to commence a parentage action, yes, but I think our ability to challenge a presumption is pretty limited because we don't have the facts. We might learn from the parties, oh, I'm married. And then because we're officers of the court, it would behoove us to let the court know that there might be a presumption of parentage. But we can't just go to court without the parties there to testify.
Right, for at least challenging under the
Exactly.
presumed parent. There may be other areas, but Ella and Barbara.
I don't want to go down a tangent on here, but I just want to acknowledge that held out the child is really doesn't mean anything to me. So I want to just confirm my assumption, which is that in court proceedings, this means something's not defined in this chapter.
That's a great question. And I think if you go back to section 401, which defines presumptions of parentage, Yeah, it's not, I don't know, Michelle.
Yeah, I can put it back.
You can just explain.
So one of the legal presumptions of parentage, we are looking at section, subsection A4 of 401, is that a presumption can be created if the person resided in the same household with the child for the first 2 years of the life of the child, including temporary periods of absence, and the person and the other parent, who might be the birth parent, openly held out the child as that person's child. So we call it the holding out presumption, which can be created if you live with the child from birth through the first 2 years of life. And so that language is in the section of 402 that we're seeking to amend, because that is a potential presumption of parentage. And if you've held yourself out, even if you're not the genetic parent, if you've held yourself out as a parent from birth through the first 2 years of life, another presumption actually applies to you. Does that make sense?
Yeah, this is the first place about that language, and then this is, I'm seeing it come up. I'm just acknowledging that it just doesn't mean anything to me, and it's not defined.
I was
But
thinking, you might talk
presuming
about, it's not just that you live with the child, it's that you are behaving in a way out in your community as a parent with this child. You are taking that child to their daycare. You are, your doctor's appointments. You're acting in a parental role for that child.
And Polly wants to weigh in as well.
I just want to share, it's a very good question. From my practice as a family lawyer, holding out is a term of art in family law and has a relatively specific meaning, as Michelle and Jessica were describing. In courts, it's one courts are very familiar with. It's the holding out presumption of parentage has been in the Uniform Parentage Act since 1973. So it is a term of art that I think, speaks to someone acting as in a parental role.
That's what I was figuring. It's not defined. This is just helpful for us to hear that. Thank you.
Barbara?
So I have a couple of questions, and I may just be totally off the wall, but so I'm I'm very familiar with adoption situations and foster care and adoption, and I'm just wondering, given that there's a different section, and I notice it's not in this bill, like this section wouldn't open it up to like a foster parent, and then there could be very contentious situations, and I just wondered how whatever change that we obviously need to make happens. How do we deal with that situation, as well as I think of the abuse of X, who will try to hold stuff up or interfere, and that made me wonder about like having the court be able to have like a neutral person in certain situations help figure it out rather than try to. So I don't know if that's a direction to go in, but that just.
Can I just add, just, would that be more of a de facto parent kind of issue than presumed parent? Because we can get to that if we want to.
Okay, well, yeah, okay, maybe.
Am I,
Yeah.
I don't want to get too far off of
Yeah,
until we
right.
finish
Sure.
through the presumed parent component of it. If
Yeah.
it does have something to do with presumed parent, please
Right, yeah.
answer. Otherwise, let's hold that question
Yeah,
until.
okay.
Yeah, I think you're talking more about a de facto parentage
Okay.
situation, and then adoptions are, as you.
Right,
Whole
yeah,
nother
okay,
type.
all right, but, and they
Yes.
wouldn't be able to access, anyway.
Yeah.
The other thing is, I'm just wondering, given how complicated these are, like, we could head off a lot of them if part of our law was a handout that everybody got when they're, well, not all of them, but where it's like, the situations you explained, it's like, how would people know that? And is there a way to make sure that people get that information?
So, one of our mandates, the Office of Child Support's mandates, is to provide educational materials to birth centers about voluntary acknowledgements of parentage. And we have a brochure. We disseminate that to the birthing centers. We also have gone and done, when the Parentage Act first passed, we went on a roadshow and went to birthing centers to explain, then because we had to create a new form, voluntary acknowledgement of parentage form. That literature that we've created does talk about who can sign a voluntary acknowledgement of parentage, how it gets signed. But we're talking about a whole other category of parentage, and I don't know, I'm just speaking as of remembering giving birth to my own children. I probably would have had no idea what that form said. So I think it is really complicated, complicated stuff, and
Yeah, anyway, sorry.
Very cool.
Can I just chime in? I mean, I think the goal is for people, I mean, on the form, I haven't read Vermont's form in a while, so I'm sorry, and I should do that. But usually those forms themselves and the instructions that come with it indicate that if your child was born within 300 days of marriage, you have to have that affidavit of denial with the voluntary acknowledgement. I think the reality is, some folks make mistakes. Some folks don't raise their hand early enough to fix what's going on with their family because things are going fine. Trying to, anticipate some of those situations could be helpful. But I do think the intent of the current forms is very much to provide folks the guidance they need in the hospital.
Thank you.
Yes.
So do you find much pro se work going on with this? Now more so than before? Because it seemed that, in the family court, arena, a lot of the folks, at least, in a period of time that I was there, they were represented and there was a few. So are we seeing more people doing the pro se?
That's a great question. I will speak to our experience. So the Office of Child Support, as I mentioned, we are filing many actions to establish parentage and related obligations. And the vast majority of the parties in our cases are pro se. They're not represented by counsel. And it puts us in a hard position because we can't give legal advice to parties. And so when these tricky situations arise, we certainly can say, you should talk to a lawyer. Some people do, and some people can't afford a lawyer. And so I think, some of the problems that we've been seeing with, presumptions of parentage and not knowing that you have to have the ex-husband sign a denial of parentage because the child was born within 300 days of a divorce. People, as we've been discussing, they make mistakes, or in the example I'm giving, it was actually, the child was born in Massachusetts, so it was actually a Massachusetts form. And then they get to court and, especially if they're receiving public assistance, most people don't have the money to hire counsel, and our, legal aid is so backed up. It's really hard to get advice from pro bono lawyers in Vermont. So we see the majority of our cases, parties are not represented. It's much better if there's a complicated situation and parties have lawyers who can help them navigate the complexity of all of this.
Okay, we are halfway done with this section, which I promise is the hardest thing in this bill.
Yeah,
And
yeah.
then it's like smooth sailing, so we're almost.
Keep going.
Yeah, let's keep
Okay.
going.
So I think we covered
Two.
subsection B1 and 2.
Two, so the three, that the child has more than one presumed parent.
Right, and so this we sort of touched on this before. There are situations where a child might have more than one presumed parent. An example could be a child is born within 300 days of the birth parent's divorce to their ex-spouse. And you might have another parent who openly held them, lived with the child from birth through the first 2 years of life, and they've held themselves out. and the other parent held themselves out as the parent, the child's, the parents of the child. And what this, we'll talk about it a little bit later on, but if there are multiple presumptions of Parentage Act says you need to do a best interests of the child analysis under Chapter 2. And that could mean that both presumed parents are parents. It might mean that, a presumption is challenged and that person is found not to be a parent. But it's all about making sure that the court is adjudicating parentage based on the best interests of the child and the relationships that the parties have with the child. That makes sense.
Yeah.
Okay, so going into subsection C, and this is where we get a little wordy here, but I think the best way for me to summarize subsection C is it's trying to give guidance to the court, and we're not talking necessarily about challenges here. We're talking about how the court should consider adjudication of parentage when there are presumed parents. It's trying to give the court guidance about what needs to happen depending on who's bringing what up. So subsection C says the following rules apply in a proceeding to adjudicate presumed parent's parentage of a child if the person who gave birth is the only other person with a claim to parentage of the child. In other words, if no one is challenging the presumption, so subsection 1 says, if no party to the proceeding challenges the presumed parent's parentage of the child, the court shall adjudicate the presumed parent to be a parent of the child. I'll give you an example. Birth parent is receiving public assistance. I'm going to use gender terms here. She's married, not living with her partner, her spouse. She's identifying her spouse as the parent of the child. If no one, we bring that action and no one is contesting the presumed parent's parentage, you're the parent. There's a legal presumption that you are a parent, and the court will adjudicate the presumed parent to be the parent of the child. So that's an uncontested situation.
So is this provision then a situation where you're trying to establish that there's a presumed parent?
So this could happen.
It's not challenging the presumed parent.
Correct. So if OCS is initiating an action to establish parentage and related obligations with a party, a birth parent, let's say, and we're naming the presumed parent, the spouse, as the other parent of the child, and the parties get to court and they say, yep, we wouldn't be asking the court to issue a parentage order because parentage is established by this legal presumption. But if everybody agrees, yep, we're the parents, the court's going to move along and adjudicate custody and child support.
I guess, yeah, that I was just wondering where since this is a challenge to presumed parent, that's why.
I think probably, maybe I'll just put a new 404 and or 402A or something to take it out of there if it doesn't really need to be in where it is.
Well, unless what you're saying that OCS says you're the presumed parent, it's not adjudicated and you're charging child support and then there's a case that comes after that, but that would be a challenge. That would be the presumed parent saying, no, I'm not the presumed parent. That'd be a challenge to it.
I think what might be tricky here is that this is a big beefy section, and the only section that really talks about challenges is subsection C. Subsection C does talk about what the court has to do if there's a challenge before. So subsection B talks about challenges to parentage after the child is more than 2 years old.
Right.
Subsection C does talk about challenges when the child is less than 2 years old, because you can bring a challenge to a presumption of parentage if the child is less than 2 years old. And so what subsection C is trying to assist with is tell the court, okay, if these are the parties to the case and there's no challenge, the presumed parent's the parent, and we'll go through the rest of them. But if we wanted to rearrange this, Michelle, we could certainly do that if makes it easier for folks to follow. This is hard.
Okay, all right, we'll work on that.
Yeah, but just to ground the subsection C, this is trying to give the court guidance about what to do in a case where there is a presumed parent, the child is less than 2 years old, and there is a challenge and there's not a challenge. So subsection C1 is basically saying if if no party is challenging the presumed parent's parentage, the court's going to adjudicate parentage, that presumed parent to be a parent of the child. That's pretty straight. That's the easiest one.
That's good.
Yeah, Karen.
So this is helpful to get that context that this is before a child is 2 years. It just makes me one. So is this just not spelled out anywhere, kind of these proceedings of how you handle these challenges? Is that what we're trying to fix here? And you're hearing that there needs to be some guidance in it? Because I would think this is what's happening already.
Right. So the current Parentage Act is pretty sparse on this topic. And this is complicated stuff. And I think when we were looking at Connecticut's law and the UPA 2017, we were thinking that this would give the court sort of a guidepost for, okay, what are the facts and circumstances surrounding this case? How old are the children? How old is the child? Is someone challenging a presumption of parentage or are they not? And, one of the added complexities here is that, because, the presumption of marriage, as I said, is an old law. It's a presumption of legitimacy, but we have same-sex marriage and we have children who are conceived through artificial reproductive technology. And then we have kids who are not necessarily conceived through artificial reproductive technology. And what do you do? Historically, a presumption of parentage was challenged through genetic testing. But sometimes you can't challenge a presumption through genetic testing if the presumption is not based on genetics. So I think what this section is trying to do is give guidance to the court about how to deal with different scenarios based on the different compositions of families.
Okay. And that there are more opportunity for challenges, or there's just diverse needs of challenges now. And so this is trying to be added to address that and give some guidance, whereas that wasn't necessarily needed before.
Yes.
Right.
Yes.
This is helpful because I'm like, well, why wasn't this in there the first time it went through?
Well, this was a big piece of
Yes.
legislation and things have evolved. And so I think it's time for us to look at this again.
No, this is helpful. Thank you.
So,
And
okay.
if it makes you feel better, I think some of the pieces based on Maine, like Maine recently tweaked its presumptions and challenges to presume parentage, I think needing to realize they needed to update this as well. So this might have been one of the pieces more based on Maine. And just to share, Maine has also added more layers to theirs.
That's right. Yeah. So we're not, Vermont's not the only state that's looking at their laws and trying to make some changes based on, experience with working with it. Okay. So subsection 2. If the presumed parent is identified under subsection 604A of this title as a genetic parent, subsection 604 is the chapter that deals with genetic parent. So if that parent is identified as, the presumed parent is identified as a genetic parent, and that identification is not successfully challenged through DNA testing. In other words, the DNA testing says, yes, you are a presumed parent and you are also a genetic parent. The court will adjudicate the presumed parent to be a parent of the child. So if you're a presumed parent and you are also found to be a genetic parent, the court's going to say you're a parent. Subsection 3. If the presumed parent is not identified under subsection 604A of this title as a genetic parent of the child, and the presumed parent or another party challenges the presumed parent's parentage of the child, the court shall adjudicate the parentage of the child in the best interests of the child based on the factors listed in subsection 206A and B of this title. Section 206A and B, that's the section of the Parentage Act that gives the court guidance about how to adjudicate parentage in the best interests of the child. This section goes on to say challenges regarding the parentage of a child born through assisted reproduction must be resolved under chapter 7 of this title. That's the title that covers parentage through assisted reproduction. This actually is helpful because it addresses one of the issues that I just discussed, which is that, you know, sometimes you have presumptions of parentage created by marriage. You might have a same-sex couple. We actually have had a case where a lesbian couple was married to each other. They're still married to each other. They separated. During the separation, one of the spouses had an extramarital affair with a man, became pregnant. The couple briefly reconciled, and then after the child was born, they separated again. So you have a presumption of parentage, but it's not based on genetics. And under our existing law, you know, I think the courts have struggled with how, if we've always challenged a presumption of parentage through DNA testing, how do we rebut a presumption that's not based on genetics because it couldn't have that? So I think what this amendment is telling the court to do, you're going to go and look at the best interest of the child factors. Because again, you know, it's about the relationships between the child and the parents, the presumed parent, the birth parent, and other parents. So does anybody have any questions about that? The exception, of course, being if the child was conceived using ART, then you have to look at chapter 7.
So I'm just gonna, we hit this a little earlier, but I'm just gonna real quickly just refer back to you around best interest factors that are up there in 206.
Okay,
So
8:10, all right,
10.
rocking now.
So after subsection D, man, it's smooth sailing, I promise.
No problems, I have a question on a later language.
You do?
I, in fact, do.
Oh, damn. Well, thank you. Thank you for being patient with me. This
is very, very
tricky
helpful.
stuff.
Very helpful.
So subsection D, this is a new section. I'm going to read it and then try to interpret it for you. Subject to the limitations set forth in this section and in section 401 of this title, if in a proceeding to adjudicate a presumed parent's parentage of a child, another person, in addition to the person who gave birth to the child, asserts a claim to parentage of the child, the court shall adjudicate parentage pursuant to subsection 206A and B. What does this mean? So this particular section of the law might cover a scenario where an alleged genetic parent is seeking to adjudicate their parentage and there is another presumed parent. Somebody has a reason to believe that because of a relationship they had with the birth parent, they might be a genetic parent. They might bring their own action to establish parentage. In those scenarios, the court would have to go to section 206A and B and look to see what's in the best interest of the child, whether it is in the best interest of the child to order genetic testing, for example, or not. So this would be a case where, you know, it's not a two-party proceeding. There's another person, because if a alleged genetic parent brings a parentage action and they know there's another potential parent other than the birth parent, they are required to give notice to that parent under chapter 1 of the VPA. So if you got multiple people claiming they're a parent, the court's going to look to see what's in the best interest of the child when they're adjudicating parentage.
Just a question, not about this language specifically, but about current practice. Since these 206A and B, the best interest guidelines exist, is that what courts have been relying on? Are we essentially putting into statute existing practice?
So in large part, I think the answer to that is yes. However, this is complicated stuff, and it's complicated for judges, it's complicated for magistrates. And, you know, in our cases, you know, we can't, you know, we can't advocate for parties. But I would say that in these complicated situations, courts are reluctant to order genetic testing in a scenario such as the one I just described, where, you know, someone is filing a complaint saying, I'm the parent, even though she's married to somebody else. There's also provisions in the genetic testing, chapter 6 of the VPA, that say the court can't order testing unless it's in the best interest of the child. And so I think what these amendments are doing in this section of the VPA are just codifying in a more formal way. This is what you need to do, court. You need to look at the best interests of the child standards.
So I'm struggling a little bit with C3 and 3D and the distinctions between them. And I think because maybe again, I don't understand this area of law very much, and may just be something I'm not understanding. So like in 3, what I'm seeing is, so basically you have a presumed parent who is not been identified as a genetic parent under that 604A language. And then either that presumed parent or another party challenges, then you'll have a best interest analysis. And so in D, subject to limitations set forth in the section 401, which has to do with presumptions, in a proceeding to adjudicate a presumed parent's parentage of a child, so it's sort of same situation, another person, in addition to the person who gave birth to the child, asserts a claim of parentage. It seems to me like they're very, very, very similar situations. And so I guess I was wondering, you know, what's the difference between that two, and why does 3, you know, sort of, why is the genetic language there, and 4 and D, why does that not have genetic language there?
I think that's a great question, and I think you're correct. They are very similar. I would say the distinction between subsection C3 is that in that scenario, the presumption of parentage is not based on genetics.
Mm-hmm.
And so if you ordered genetic testing, it wouldn't rebut that presumption, because the genetic test results would show that that person isn't a genetic parent, even though they are a presumed parent. I think D is a little bit broader in the sense that it could and would encompass a scenario where the presumption of parentage might be based on genetics. Parties were married, child was born during the marriage, but someone else is saying, I actually am the genetic parent of the child. What would the court do? You know, the court would have to determine whether it would be in the best interest of the child to order testing to try to rebut the presumption that the presumed parent is the genetic parent. It could also potentially involve a scenario where the presumed parent isn't a genetic parent, but someone bringing a challenge might be. You know, that might, an example could be similar to the one that I gave, where you have a same-sex lesbian couple who have a child's born of the marriage. Maybe that child, both of those parents parented that child together, but there is a potential genetic parent out there. That would be a scenario where under subsection, that could fall under either scenario, actually. But I think the result is the court's going to look to see if it's in the best interest of the child to either order that both potential parents are parents. So in other words, not rebut the presumed parent's parentage, but order that, they are a parent and so is this other person. Again, this is complicated stuff, but I think it's the idea here is that we're trying to we're trying to point them in the direction of, if you have these scenarios where you have multiple parties asserting claims to parentage, you have to look to 206 to determine whether it's in the best interest of the child to rebut a presumption through genetic testing, potentially.
Do you think it makes sense to include the language challenges regarding parents of the child born through assisted reproduction resolved under Chapter 7 of this title in subsection D there? Just because I misspoke a little bit in my question, but sort of what I was trying to get at in part is that it seems that because those two are so similar, and clearly there's the need for that language in 3, if it might make sense to put that language in D as well.
I'm going to want Polly to weigh in on this, but I don't see any reason why we couldn't include that language in subsection. Polly, do you have thoughts about that?
No, I'm sorry. I don't.
Yeah.
I think it's, a good thing to consider and see how it works. Yep.
Thanks.
Okay, all right. So other questions on that section?
Okay. I'm gonna go and move on to section 5.
And stuff.
For de facto parents. Is that the only?
Oh, and this is where Barbara could have a question, but she's not here.
So I might just stop here for a second and just show you some of the ways in which a de facto parent can be
So there really isn't,
established.
there's just, okay, change for a subsection. Okay.
Right, to a subsection and then a technical.
Important. Exactly. This is area that I think Barbara had questions on.
Okay, I just popped up here, a section that we are amending. I guess I could have just used the bill, right? And not gone to that statute. It was all in there. Sorry about that. I thought I was helping. Back to that. Okay. So section 501, we're talking about de facto parents, already mentioned that. So basically someone who isn't a genetic parent, not a birth parent, not a presumed parent, not a parent through assisted reproductive technology, an intended parent. They are a de facto parent, someone who is essentially functioning as a parent for a child. And you'll see some of the factors that are to be considered. In existing law on page 11, court shall adjudicate the person who claims to be de facto parent of the child if the person demonstrates by clear and convincing evidence. So we're using intermediary standard there of proof that the person resided with the child as a regular member of the child's household for a significant period of time. The person engaged in consistent caretaking of the child. The person undertook full and permanent responsibilities of a parent of that child without expectation of financial compensation. D is that the person held out the child as the person's child. The person established a bonded independent relationship with that child that's parental in nature. The person, another parent of the child, fostered or supported the bonded independent relationship. And continuing the relationship between the person and the child is in the best interest of the child. Remember, we're always going back, when we talk about best interest, we're going back to 206, right, in here. And again, just a reminder, it's different. The factors for considering what is in the best interest of child, different under here for establishment of legal parentage than it is for parental rights and responsibilities that you're determining under Title 15, okay? Because there is a different laundry list of of what the court is weighing.
That's
So that's where DCF runs into this, a lot more often. With foster parenting and kinship placements, would you say?
So that's probably a better question to direct to family services. I would say that we definitely have de facto parentage cases, but I don't, because as Michelle was going through the criteria for de facto parentage, you have to be acting as a parent, holding out as a parent without expectation of financial
Financial.
compensation.
That was the kinship part.
So, right, so if a child is placed with kin, they are also entitled to a subsidy.
Right, that's
For
right.
care, yeah. So, I don't think, I remember this being discussed quite a bit when the Parentage Act, when we were going through the process of adopting it. And I don't think that I don't think a lot of foster parents and kinship placements would technically meet the criteria of a de facto parent.
Because, when we were doing this before, that's the reason it came back to me like a bad dream. No, not a good bad dream. In some cases, there were in the kinship placement because of the status of, financial status, of the family. They, they just did not take any compensation. So that, put them in a different category. There weren't, they were well-to-do enough that, they just accepted them, as another member of the family, because, there might have been a death in the family, that type of transfer. And, without going through, family court and, changing names and,
Yeah, that's a tricky question for me to answer. You might want to inquire of family services, but, I think a lot of these kinship placements end up in a permanent guardianship scenario, which would give that person parental rights. We could try to collect some data about that, but I don't think that's something that. we
Right,
see.
that's all separate and apart
Yes.
from what you're doing here around establishing legal parentage. So if a child is in the care and custody of the commissioner, and Ben does all of this stuff, so I'm really just kind of winging it, but is that, and then they're placed, a kinship placement or something, it's not changing the legal status of those caretakers in terms of assigning them the role of the legal status of a parent and the rights and responsibilities that come with being a legal parent.
that's me.
So we're on to section 6, or I'm sorry, Joe.
So, I was curious, so I was reading ahead in 502 here. Are there circumstances, it seems to me, and correct me if I'm wrong, that this section here, 501, only applies to de facto parents who are being sought to be named de facto parents by a court. Are there any circumstances where a presumed parent would seek to have a person named as a de facto parent?
That's a great question. Only a person who is asking the court to adjudicate them to be a de facto parent can bring a petition for de facto parentage. Another person, like their spouse, for example, couldn't petition the court to ask their spouse to have de facto parent status.
Got
And
it.
I think that's answered in 5(0).
Yes, in the lead-in language.
Okay, great, thanks.
Right, so if you look at, no, so I think it's in A1, right? Proceeding to adjudicate the parent of the person who claims to be a de facto parent.
Got it. Cool.
The court shall adjudicate the person who claims to be the de facto parent to be a parent if the person demonstrates by clear.
Got it.
Right. Okay, so we just talked a little bit about, I just wanted to kind of go over that existing language about kind of, so you can kind of imagine who these de facto parents are. This small tweak and subdivision A2 at the bottom of page 11, that's just a technical. And then the next change is on subsection B. And what you'll see is that in a proceeding to adjudicate parentage of a person who's claiming to be de facto parent, if there's more than one person who is a parent or has a claim to parentage of the child, and the court determines that the requirements of A, which is around assessing whether or not someone is a de facto parent, are met by clear and convincing evidence, the court shall adjudicate parentage under, and right now it refers back to 206, which is the best interest standard. And so what you have is like the factors to be considered in subsection A, and then you have in subsection B, and again, I'm just going to go to that language B so that you can see it. Because we're talking about there's more than one parent already there. So we're talking about that there's the possibility of there being three parents with this addition of this de facto parent. So you'll say on B, it's being more specific, referring that we're not doing a whole analysis of best interest again. We're looking at preservation of the parent-child relationship. So consistent with establishment of parentage, a court may determine that a child has more than two parents if the court finds it's in the best interest of the child to do so. And that it doesn't, and then referring to that language that we talked about a little earlier, that it doesn't mean that you have to find that an existing parent is unfit in any way to add another parent to the mix.
Sorry, I think I'm almost there, but you said they didn't have to re-go through. So in this scenario, they would have already weighed the best interest of the child?
Right.
Well, like why isn't this A and B, or leaving in section 206? I'm still not following why we wouldn't be asking the judge to prove.
Polly, do you want to chime in? I see that it can go either way, but Polly, I think you might have a different opinion on
Yeah.
that.
I could see it going either way too. I think that the intent of the change is to be more precise and to and I believe Connecticut made this more kind of precise site to be, and it's in something I'm drafting for Massachusetts at the moment, which is to suggest to the court that, first of all, if you have proven yourself to be a de facto parent, it is such a rigorous standard, right? Like those 7 requirements by clear and convincing evidence, which include a best interest analysis, are incredibly rigorous. So that if you have met that standard and you are a de facto parent, and there's already a parent established, already 2 parents, I think this centering on B is trying to indicate that the court doesn't have to go weigh all of the factors of A, right? Like you're not competing necessarily, you're not showing that one claim should prevail over another. This person is a parent, and they have met that de facto parent standard. But the question is, is it in the best interest of the child to have more than 2 parents, right? So that it is just really focused on the issue of 2 versus more. So I think that's the goal. I will say, just to share, like in Maine, interestingly, in Maine, if you establish yourself as a de facto parent, you just become a parent. There is no competing claims analysis at all. So I think states do this differently. I think we were just trying to make it a little clearer that you're going right to that 2 versus 3 analysis, because the de facto parent standard is so rigorous in and of itself and
And
includes
it's
it.
already an A1 G.
Yes, that's what
So on
I
page-
had just missed.
Right, yeah, so like on page 11, to just qualify and bring the action, you have to meet the best interest there. So I get why they were saying, oh, let's just focus on B in this section, because you already have to clear that hurdle, and let's not like point them back to that. But
Understood.
I get what,
I just missed.
I get what you're saying. All right, any other questions?
Section 6.
Okay. So this is the chapter for assisted reproduction, as you can see. And right now, there is a requirement, you'll see in subsection A, that a person who intends to be a parent of a child born through assisted reproduction shall consent in writing. And so the new language is providing for a little more flexibility there. So you'll see at the language, top of page 13. So it could be in a record that's signed before, on, or after the birth of the child by the person who gave birth to the child and by a person who intends to be a parent of the child. And then the new, the broadening of the language is in subdivision 2, which is, or in an oral agreement entered into before conception, that the person who gave birth to the child and the person who intends to be a parent of the child intended that they will be parents of the child. So it is opening it up a little bit so that an oral agreement between the birth parent and the intended parent would suffice. And it doesn't necessarily have to be in writing.
Joe.
I'd just like to hear a little bit more about this because it worries me a little bit. I'm sort of like remembering back in law school, the statute of frauds. Like there are some contracts that are so important, they must be in writing and they must be signed. And I sort of feel that, when we're talking about parentage of a child, that, it seems like it opens the door to someone saying, I had an oral agreement, and of course that needs to be proven in court and blah, blah, blah. But still, there's something that seems like there's a weakening here. And so I'd just like to hear more about that weakening.
Sure. And I just took the thing down because I'm going to kick it to Polly to make her argument as to why this is good policy.
Yeah, which yeah, I mean, this is one I think that is particularly near and dear. And I think that particularly for LGBTQ parents who often use more informal forms of assisted reproduction is incredibly important. And I have litigated a lot of cases where there is not written consent. I think, anyway, so let me just start out by saying I think there's, the goal in the assisted reproduction piece is to make sure that we have clarity in like who's a parent of a child born through assisted reproduction. For many families, they are, because of the expense of fertility healthcare, because of a lack of availability of gamete donors, many folks do at-home insemination, for example. And many folks in our community who are low income, don't have access to lawyers. In my experience, actually very few people write this stuff down and sign an agreement. And that courts are used to, like, let's say, for example, Massachusetts, since 1981, we've never had a writing requirement for consent to assisted reproduction. And the courts have really been able to differentiate and like what is an agreement to assisted reproduction and what is not. I think that in the VPA in 2018, I think the intent was to say, we'd ideally like to have it in a record, but if you don't, a court still can determine that there's evidence of consent, right? And so I think this is actually not that big a change. It's just a shift in emphasis to make it clearer to families and to the court that you can have both, you can have it in a writing or you can have oral evidence and still then we're going to have that backstop to the court can make the determination if need be. This is absolutely right. This is a weighty thing to have a child together, but unfortunately for many folks, they don't take that step of writing things down. But that's not to say that there isn't some other evidence. Like, for instance, I've used evidence of people send emails, people send texts, people send holiday cards to their family. There are birthday shower invitations. There is often indicia of written evidence, but it's just not a record that people have signed. So we feel that it's very important that a written consent requirement that is hard and fast can leave some children out. And we want to make sure that we're capturing as many children as we can. And another piece I will just say that's in this is which might be a little too weedy and you're too close to lunch, so you might, but it is also kind of Vermont at the time in 2018 followed pulled in a piece of the Maine Parentage Act about having a consent form through the Department of Health. That was in the Maine law because Maine did not update the voluntary acknowledgement provisions to make them inclusive of all families. Maine has since done that. Vermont did it at the outset. So Vermont from the outset in 2018 has a VAP form that is inclusive of all families, so that this Department of Health form is confusing and kind of pulls people away from that most protective document that we want them to sign, which is the VAP. So in any event, so that's a little bit about this section. I don't feel that it kind of weakens or brings clarity to me. It feels more protective of children born through assisted reproduction. And of course, we will continue our work to try to encourage people to put things in writing.
That's very helpful. Thank you.
Actually, if I could just chime in, we've had a couple of cases that similar to what Polly described, where families don't have the funds to work with a fertility clinic and they engage in assisted reproductive technology on an informal basis. And when we have had those cases and the court has had them, it's been really tricky to figure out what to do. So especially when everybody agrees that the intent was that, they were going to conceive a child, but the donor was not going to be a parent. So just thought I'd throw that out there. We've seen some of those cases in our work.
Thank you.
So
Section 8.
I am going to speed through the last few sections, if that's okay, because I know we have to be in a noontime meeting together.
Probably a few minutes.
Be a few minutes late, but I think we can finish this. Section 8. So this is if you get divorced, a person who has petitioned for divorce or a person who has been served with a complaint for divorce may proceed with assisted reproduction provided at least 60 days have elapsed since the service of the complaint. So this is to address circumstances where people have decided to split. Sometimes divorces, dissolutions take a long time.
Especially with the court backlog.
With the court backlog or just, circumstances. And they can drag on for, years. Someone may have frozen their eggs or sperm or whatever and say, I don't want to wait. I want to have a child, right? Maybe they've petitioned for divorce 2 years ago, but their property isn't still settled yet. And they have a new partner who they would like to, use their frozen eggs or sperm with. And so this is saying that setting out the terms under which you could proceed to do that. And it wouldn't automatically be like, even though you are still legally married to your ex-partner, that there's that presumption that they are a parent. You guys have anything, just knowing that we can always come back to this, but is there anything from the witnesses that you or anybody want to chime in on?
Oh, I would just say that I have literally seen a number of cases where unfortunately women whose biological clocks are ticking are kind of held hostage in a divorce situation by abusive spouses. And it's very helpful to have kind of an out to say, you know what, I'm going to move on with my reproductive life, which is time sensitive, in the course of litigation that is ongoing. So I think it's very helpful to people in those types of situations.
That's one quick question.
Yeah, go ahead.
Can you talk a little bit about the 60 days?
Oh,
Right.
that's, I think, to say, you know, we don't want to surprise folks, right? Like, I think it's just to allow some time to have elapsed. The complaint has been served, people have been able to file an answer. If there's something else going on, you know, perhaps there's, yeah, I mean, I think that that is a movable feast for sure, up for this committee to describe, but, I mean, to determine, but I think just to let the divorce kind of settle in for a little bit, before moving forward.
Sure, thank you.
Okay, moving on to section 9 on page 15, birth and parentage orders. So new language. Page 16, subsection B, proceeding under this section may be commenced before or after the birth of the child. And if the court determines a person is a parent of the child, either because the person gave birth to the child or the person is a consenting intended parent, the court shall adjudicate the person to be a parent of the child. And I'm trying to remember the circumstances to why this came up, because we had talked about it. So,
Yeah,
can you remind me?
yes, so these two pieces, this piece and the one a little bit farther down,
Mhm.
we had heard from, like, for instance, from family lawyers, a number of family lawyers, that pro se litigants were having some difficulty getting timely judgments and orders. And so this was trying to add some just tweaks so that to guide the court that you know, if there's an uncontested petition, to please resolve it with it in a speedy manner. And that, you know, if there's proof of consent, you shall adjudicate them as a parent. So I think the goal was to really to try to address some of those delay issues for pro se litigants who I have heard the cases are languishing for folks that do not have lawyers.
So we'll have zoning in here on that second 30 days part to tell us why we can't do that, but we can talk. So, Joe.
I was gonna say that Judge Zone's voice is in my head saying that what if they can't do 30 days? So
Okay, so we're on the same page. We'll have him in.
All right, section 10, eligibility to enter a gestational carrier agreement. There is a provision in the existing law that is on page 17. You'll see it's subsection B. So prior to executing a gestational carrier agreement, a person or persons intending to become parent or parents. So these are the folks who have entered into a contract with someone to be the carrier of the child. And it's not the gestational carrier that we're talking about in B. We're talking about the intended parents. And you'll see on subdivision 2, it's that they need to complete a medical evaluation and a mental health consultation. And we were all scratching our heads going, why do the intended parents have to have a medical evaluation? And we couldn't figure out why. We don't know if that slipped in there by accident originally, but none of us could recall. But everybody kind of agreed that it didn't seem necessary.
So this is the area I have a big issue with. And why the mental health consultation, and who is deciding whether somebody's mentally able to be a parent? Is that what you're?
Yep.
Sorry, I jumped ahead of you, Joe.
No, it's fine.
This one I've been waiting for the longest time to ask that question, so I couldn't help myself.
Yeah, no.
So I don't recall the ounce of this. This is where Kurt Hughes, who I think you have invited to testify, and I can reach out to Kurt if y'all haven't heard from him yet, but he is really the expert in these types of parentage arrangements and contracts, and was very helpful in creating this. I don't have any particular recollection as to why these things, I think, but we can revisit that. We can look at the model, at the Uniform Act and others to see who has what. I can also look at the notes for the Uniform Act and see whether or not they talk about that.
So is, Jessica or Polly have any input on that language and why we need to have a mental health consultation?
I know, I have a feeling, I know why it's in there. I mean, I think, first of all, it's very clear the medical evaluation language should come out. I mean, certainly many intended parents with disabilities specifically need surrogacy to build their family, and we would not want to exclude them in that way. I think that this is a good place for Attorney Hughes to comment. We have been in discussion about that issue. I think that from my understanding, again, I'm not a surrogacy practitioner, but I play one on TV, which is that many of the providers are going to require intended parents to go through such a consultation anyway, that there's the sense that the consultation is to make sure that people are, freely, entering into this weighty contract with the full understanding of what it entails, of the appropriate, the role of the person acting as a surrogate to maintain all the decisions, for example, about the pregnancy in their body, right? So to make sure that they're really going into this with their eyes wide open. That is my understanding and the point of the mental health consultation. Certainly, I would not want it to be any kind of gatekeeping for intended parents to be able to build their family. I do think that Attorney Hughes has some thoughts about this and how it's playing out in Vermont. And I'm happy to try to get that feedback from him as well to share with the committee.
Yeah, and we are going to try to bring him in, and this will be one of the issues we'll ask him about.
And it may be that we can refine the language as such to get more at like what Polly is saying, rather than kind of a general, because I understand what you're saying, certainly with the mental health evaluation and what are the standards and all of that sort of thing.
Stigmatizing also.
Sure.
I mean, if a person's been found to be incompetent to be able to sign contracts and such, that's one thing. I suppose.
Right. Yeah,
Did you have a question, Ellen, or somebody else? I thought I saw a hand.
I was just gonna ask the same question about the mental health conversation.
Okay.
there is one
Last bit.
last section, and that is on page 18. And we're still working in the chapter with regard to surrogacy. And so I gotta pick the lead in language there. Let's see, so what we have is on A3. If the genetic testing indicates a genetic relationship between the gestational carrier and the child, parentage shall be determined by the Family Division of the Superior Court pursuant to the other chapters or that are in here. There is the language is added in line 15 to say that a gestational carrier who is not a known family member, because and that is to address those situations where you may have a sibling or someone in your family who has stepped up to volunteer to be the surrogate and to carry the child for you. And in those cases, you don't want to, screen them out as inappropriate.
Questions on that one? Don't see any other questions. So we'll have at least somebody from legal aid, that zoning, Kurt Hughes, and anybody else that we need to hear from? Yes. And we're gonna have to really figure out how to explain the one section 4 on the floor of the house. I could imagine 100 different scenarios coming our way,
There's two strategies there.
mostly from one of the representatives from Ken's district. So
Don't throw me into this.
no, not you. I'm not talking about you. So before we break, could we close out the vote on the two bills? We had each 5.
Holly, thank you.
Yeah, thank you very much.
Thank you,
Holly, for
Holly.
being here.
Thank you.
And thank you, Jess, for being here as well.
Thanks, Jeff. I'll take over.
Please, you take over.
H 563 coach, an act relating to attempted auto theft. Yes. Thank you. And then H 780, an act relating to judicial nominating and appointments. For you, yes. Listen, no.
What?
We're offline.